Are you dealing with parental alienation? If that is the case, then this video is for you. There are situations where a former partner or spouse is trying to alienate you from your children. Your ex will not allow you to have contact or relations with your child. In this video, you will understand the law has changed from parental alienation to alienating behaviours, how to use this to your advantage, how you protect yourself from the alienating behaviours, and how to protect your children from the behaviours. Welcome to Tina Do Children Law Update. We are the only site on social media producing regular family and children law updates in conjunction with a solicitor for the past 15 years. We are going to look at a real-life situation that ended up in the family courts and how the courts dealt with it, and you will be able to apply the lessons to your situation. In order for us to understand the case we are going to discuss today, it is important for us to explain that in any court case, there are mini-trials within the court proceedings before the final hearing. So, there may be a date when the court will hear arguments from lawyers on what documents a lawyer can use in the case, and a judge will make a decision on that issue before the final hearing. There may be a fact-finding hearing, which is also a mini-hearing within the court proceedings to determine whether some facts are true or correct. Then after that is done, there may be a final hearing when the court then makes a final decision about the case and final orders. So sometimes there are mini-trials or mini-court battles within a court case before the final hearing. Having said that, the real-life situation we are going to look at is one of those mini-battles called a fact-finding hearing when the judge had to decide whether there has been parental alienation. One party did not like the court's decision and appealed the decision to the Appellate High Court. Now let's dive into the story. The parents of the children were in a brief relationship lasting less than a year. The mother became pregnant. They moved in together and separated under a period of time of less than 2 years. The mother alleged domestic abuse against the father. The children lived with both parents under a shared care order. A couple of years later, the mother said that the children had made allegations against their father. The mother stopped the children from having contact with the father. The parents decided to take the matter back to court. During a mini-trial or fact-finding hearing within the court case, the mother alleged domestic violence and serious child abuse against her ex. At the end of this video, we shall tell you where you can read the detail of the alleged abuse. The father alleged parental alienation against his ex. The trial judge dismissed the mother's abuse allegations and decided that she fabricated them and concluded that mother engaged in parental alienation. This led to the mother lodging an appeal on the issue of parental alienation to the Appellate High Court. The mother did not appeal the dismissal of her abuse allegations against the father. Her appeal included a challenge of the judge's finding of parental alienation against her from 2 perspectives. The first perspective was procedural unfairness. The judge had initially decided not to determine the father's allegations of alienation, yet ultimately made findings against the mother on that very issue. The second perspective was a substantive error. The trial judge claimed to have followed the new approach towards alienating behaviour as set out in the Family Justice Council 3-stage guidance, but failed to apply it properly. The mother's lawyer drew the higher or appellate court's attention to the law and authorities for the new approach towards alienating behaviour, namely, Re-C, Parental Alienation, Instruction of Experts reported in 2023, which established that parental alienation is a factual finding, not a psychological diagnosis. Re-Y Experts and Alienating Behaviour, this the authority for the modern approach, reported in 2026, where the court emphasised the new approach and most recent guidance. Family Justice Council, FJC Guidance, December 2024. The authoritative 3-stage approach. The key concepts in the new approach or guidance are AAA, known as attachment, affinity and alignment. Normal reasons why a child may favour one parent, not manipulation. AJR, known as appropriate justified reaction. A child's refusal may be justified by the estranged parent's behaviour. The lawyer for the mother referred the Appellate High Court to the definition of AAA within the glossary of terms. Attachment, affinity and alignment, AAAA. Reasons why children may favour one parent over another, or reject a parent, which are typical emotional responses to parenting experiences and not the result of psychological manipulation by a parent. The lawyer for the mother reminded the Appellate High Court of the modern approach of alienating behaviours as opposed to parental alienation. It is alienating behaviours that needs to be proven or evidenced. This is set out the case of Ree mentioned earlier and can be summarised in 7 points. Number 1. As the full title to the Family Justice Council guidance makes plain, the reason for the court's investigation should be a child's unexplained reluctance, resistance or refusal to spend time with a parent, rather than the allegations that one or other parent may be making against the other. Number 2. Where a child is reluctant, resisting or refusing to engage in a relationship with a parent or carer, element 1 of the 3 elements in paragraph 10 of the guidance, then the court's focus will move to element 2 to consider whether that reluctance, resistance or refusal is a consequence of the action of the estranged parent, where it is alleged that that parent has been abusive to the child and or caring parent. Number 3. If it is found that the estranged parent has not behaved in a way in which the child's reaction can be seen as an appropriate, justified reaction to such behaviour, or for other reasons, it is found that the child's reaction is not caused by any factor such as a child's ordinary alignment, affinity, or attachment to the parent with care, then the court will move on to element 3. Number 4. It is only at the stage of element 3 that the court will focus on whether the caring parent has engaged in alienating behaviours that have directly or indirectly impacted on the child, leading to the child's reluctance, resistance, or refusal to engage with the estranged parent. Number 5. Thus, where domestic abuse is alleged, and there is a cross-allegation of alienating behaviour, if a fact-finding process is required, the focus of the fact-finding must be to first determine the issues of domestic abuse, and secondly, to consider whether the child's refusal to engage with the estranged parent is an appropriate justified reaction to any abusive behaviour, or that what has occurred is the result of protective behaviour or a traumatic response on the part of the victim parent. Number 6. Courts should not follow the route adopted by the judges in the case of O and P and the present case in determining the issue of alienating behaviour on its own and without determining the underlying facts and, where it is alleged, the primary issue of domestic abuse. And number 7. Courts should not appoint an expert to advise in cases where a child is reluctant, resistant, or refusing to engage with a parent unless and until there is clarity and, if necessary, facts that have been found as to the parent's past behaviour towards each other and the child, and, if domestic abuse is proved, whether the child's reaction to that behaviour is an appropriate one. The mother argued the trial judge fundamentally misapplied the Family Justice Council framework on the new approach or on alienating behaviours. The lawyer for the father of the child at the Appellate High Court argued that the trial judge satisfied all 3 stages of the Family Justice Council guidance. The lawyer for the children's guardians on appeal supported the mother's appeal on the first ground, that the trial judge acted unfairly in making a finding of parental alienation. The trial judge did not properly apply the Family Justice Council 3-stage approach. No Stage 1 analysis was properly completed by the trial judge for a child. The trial judge completed an inadequate Stage 2 analysis for a child and did properly consider the attachment, affinity and alignment, AAA, or appropriate justified reaction, AJR. The trial judge provided no explanation of how any alleged manipulation caused the children's reluctance or resistance or refusal. The guardian's lawyer concluded that the trial judge's approach fell outside the known parameters of the new guidance and was procedurally unfair. Now let us turn to the appeal court's reasoning and decision. The Appellate High Court endorsed the view expressed on the case of Re-Y, Experts and Alienating Behaviour, the Modern Approach, reported in 2026 in Family Court of England and Wales at page 38. The court must have regards to the Family Justice Council guidance on responding to a child's unexplained reluctance, resistance, or refusal to spend time with a parent, and allegations of alienating behaviour, published in December 2024. Alienating behaviours are a form of abuse and must be pleaded, evidenced, and proved like any other allegation. A court cannot infer alienation simply because Parent 1's allegations of abuse are unproven, or Parent 2 fabricated allegations. Fabrication does not automatically equal alienation. The burden of proof lies with the person making the allegation. The FJC 3-stage test and the President's guidance in Re-Y must be followed. The judge did not treat alienation as an allegation requiring proof by the father. The judge accepted he lacked evidence of P's views. Therefore, Stage 1 of the FJC test was not met for P. No alienation finding could properly be made in relation to mother. The judge found a child's animosity was not caused by the father, but failed to consider AAA, alignment, affinity, attachment, or other non-abusive explanations. This was a fundamental omission, especially given evidence suggesting AAA may have been relevant. The trial judge did not identify what behaviours amounted to alienation. He did not explain how they caused reluctance or resistance or refusal. The judge's conclusion that the mother fabricated an allegation to prevent contact is not the same as a finding of alienation. A parent may fabricate to stop contact without influencing the child's views. The Appellate High Court therefore revoked or set aside the trial judge's decision against the mother of parental alienation. However, 8 months later, since the fact-finding judgment was made by trial judge, the Appellate High Court sent the case had to back to the lower court, as the Appellate High Court only looked at the decision of the mini-trial or fact-finding of the ongoing court case. Before sending the case back the lower court, the appeal court made the following notes or directions. A significant period of 8 months has elapsed since the original fact-finding decision. New evidence has been presented to the appellate court, including CAFCAS reports, all prepared on the assumption that the mother had been found to have committed parental alienation. The children have since spent time with the father. When with the father, the children have been relaxed, comfortable, enjoying his company. But when the children were asked about their views of their father, they revert to the negative attitudes that had concerned the original judge. This contrast is described as of considerable interest and will clearly be relevant to any future assessment of the children's true feelings. The appeal court decided not to order a fresh fact-finding hearing into alienating behaviour because the children's circumstances have changed since the original hearing. The original judge had excluded the father's allegations from determination. The father may no longer wish to pursue an alienation allegation. The family court may conclude that no fact-finding hearing is now required. The appeal court therefore considered it inappropriate to impose such a hearing on the lower court. The case was remitted or sent back to the lower family court with the following directions. The family court must decide whether a fact-finding hearing into alleged alienating behaviour by the mother is still required. If so, whether it should be a separate hearing or part of the final welfare hearing. The case was sent back to the family court, but it must not be heard again by the previous trial judge. And for some of us who want to do more research on this case or find out the details of the alleged child abuse or the new law or approach towards alienating behaviour, the case law is Re Mother, Appeal, Alienating Behaviours, Fair Procedure reported in 2026. England and Wales High Court, from page 783 Family. So there have the UIT. There are many explanations for your child's behaviour. Do not blame the child. Do not forget to make notes of the behaviours both of your ex and your child and speak to a family lawyer to advise you on this. You can also speak to a local authority children's social worker about any welfare issues or concerns you have about a child. This is a Tinadu Children Law Update. Please let us know what you think about this update in the comments below, and if you have not yet hit the subscribe button and click on the notification button, please do so. I look forward to seeing you in my next video. Thank you.